Welcome to Your Texas Land, a place where we take a deep dive into all things about Texas land. I'm your host, Brad Glover. Excited to have you join us today. In each episode, we explore topics that are of interest and may affect you as a landowner in Texas. And today, I'm happy to have Cassie Gresham join us. We're going to be talking about potentially the top 5 litigation issues that landowners might encounter. Now, Cassie, I imagine there is a host of litigation issues that landowners might encounter.
Sure.
So we're narrowing it down a little bit.
Yeah. We're going to talk about the top 5 that we see in our practice. And we've seen for, 20 years trying to help landowners kind of navigate that and know that we're here if these things come up. So
great. Well, let's get started. What do you see as the number one issue that you face or landowners face?
A lot of landowners face an access easement dispute, and those can kind of take 2 different forms. Either you have a property that doesn't have access or has questionable access, or you have a neighbor who's trying to get access through you. So yeah.
So let's stop. So access, literally driving across the property.
Yes.
Getting onto your land.
Yes.
Maybe through someone else's land.
Yeah, that's very common in Texas that you're like, well, I own a ranch, but we drive through 2 ranches to get to my place because maybe there's not a frontage on the highway.
Okay, great.
And maybe it's a handshake deal. Or you're like, well, I don't have a problem because my family's owned this property for 100 years and we've been driving down the same road for 100 years. But unless there's an agreement about that access, more particularly a written agreement, what we call an express easement is what you would really want. Something in writing that says what your rights are, then you're not in a good place.
Okay, so even if I've been doing it for 50 years, still want something written.
That's right. So I tell people all the time, and this is shocking, but there's a myth that a piece of land can't be landlocked in Texas.
I've heard that.
People say that all the time. In Texas, we would never lock a piece of land up, or that every piece of land has access. And that's just not true. So that there are different ways to get access if you have a landlocked piece of land, but it might require going to court to establish that access. And there's different ways to do that. Let's start with, you've been accessing, your property needs access, or you've been using a road for a number of years and you're not sure. So the first thing I would ask a client is, what does your deed say? Does your deed have an easement in it? And oftentimes there's a clause at the very bottom of a deed that says you get all the rights that my predecessors and heirs had. Any and all easements, it'll just be like a blanket statement. Most people think that is an access easement or that entitles them to an access easement. And that's not true. Okay. So when you have a property description in a deed where it says, I'm buying 20 acres, you also need to make sure that what's being deeded to you is access to that property.
All right. That sounds pretty important.
Yeah. So I've seen it many years ago. I had a client who got a divorce, and the client had a divorce attorney, and that divorce attorney did a really good job on getting financial things set up, but they didn't have a real estate attorney at the table. So when the couple divided a piece of property, they gave my client 3 acres on the backside, and there's a road, and they had driven that road for many, many years to access the business that was given to my client. But she had to go through her ex-husband's property to get there, and he locked her out.
Wow.
And we could have solved that. It could have been solved if a real estate attorney was at the table with that divorce attorney. Just like I wouldn't know how to do a divorce proceeding or family law or anything like that. That's not something I practice, but we know real estate. And so I can look at a deed or a document and say, oh, how is it being accessed? That's one of the first things things I ask about.
So that's one example, and that's a great story. So how else, or what else occurs that's going to cause a change? Right? I've been doing it for 50 years.
Yeah.
Why can't I keep doing it? What are some of the other instances that may cause me to lose access to my land?
So we've had a lot of these cases. So I have tons of examples. So another case that I'm working on right now is for a client whose family owns property, and they've owned it. This was the 100-year example that I was using. And there's a public road. I wish I would be drawing a blackboard. There's a public road at the bottom near San Antonio, and there's 7 or 8 landowners that the road goes across. It's a caliche 10-foot, goes through a creek, comes out of a creek. If you saw it, you would just feel like this is just a ranch road.
Okay.
But it goes through about 7 or 8 properties. And literally, I was doing a site visit with this client probably more than 10 years ago. And we were doing some other work for him. And we just started talking about the nature of the road. And I said, he said, well, we just never have documented it. And I was like, well, do you have permission? He's like, yeah, we've been using it for, 100 years. And come to find out, the reason why he wanted to solve it is he's going to give this property to his son, and he wants to make sure that when he does that there is an access easement that his son can utilize and use. Because if you ever want to sell a property, or if your son wants to, if you want to get a loan to build a home or anything like that, the title company is going to look at it, and then they will say, oh, this property doesn't have access, so we can't insure. They'll insure the tract, but you may not be able to get financing to build a home if you don't have access there.
Wow.
So it's important. So in that case, I'm actively working with a bunch of the neighbors to work on an access easement. So we're working in a friendly manner. It's taking a lot of negotiation, but we surveyed the whole road, and we're working with each neighbor to figure that out. And that hopefully won't lead to litigation. I think it's something that we can work out as neighbors. Another instance, how this typically comes up is you have an agreement with all your neighbors, or everybody understands that you've owned this property for a really long time and you're using this road, but a new owner comes in and they change the nature of the way that they're using the road.
Okay.
Maybe it was nobody was living there, or nobody was using the road, and now they want to have a hunting ranch there, and so they're worried about people driving through that they don't know is coming through, and they want to limit the access.
Or they want to fence it.
They want to fence it.
Yeah.
And so, and they don't recognize your right because it's not in writing. What do you do about that? So at that point, you can file a lawsuit in the courts, and then you have to argue all kinds of different theories. There's an easement by necessity. There is a prescriptive easement. There's a thing called an easement by estoppel. All of those have different facts and requirements that have to be met. So kind of the landlocked idea of you can't ever have a piece of land in Texas that's landlocked comes from the easement by necessity. So a lot of people think, well, it's necessary to get to my property. I don't have any other way in.
Therefore, I have an easement.
Therefore, I have an easement by necessity. But actually, there's nothing to do with the thing. It's the test for an easement by necessity is very tied to when you purchase the land. So when you purchase the land, were you purchasing as part of a larger parcel, and the necessity was created at the time that the property was subdivided. So if your use changes over time, like somebody blocks your access, but you have another way in, or there was an issue at the time of the severance where it wasn't the necessity to use this road, then it doesn't meet that criteria. And there's different, a prescriptive easement is kind of like, I have used this road for so many years, therefore I'm entitled to continue to use it. But again, that only a court can award that. An easement by estoppel would be, you told me I could use this road, and I relied on your representation, and therefore I want the court to award me this easement based upon your representation.
So more or less a verbal agreement. You're trying to make a verbal agreement stand.
Right. Get a judgment on the verbal. And all of it is really fact intensive, right? Because you got to come forward and say, no, you told me on this date and I relied on it and I've been using it for all these years. So it gets kind of dicey when you're doing that in a court. I mean, you can go in and win. But we have cases out in West Texas where literally there's a case that we have settled that there were people that bought their land on eBay and they had never accessed the property, didn't know what road could be used to access the property. We could show them a map and say, show us where your property is and how you access it. And they would say, well, I've actually never been there.
Wow.
So I don't know how I would access it. And so all those theories by which you would, those different theories, they just don't quite fit into that box. And so sometimes judges will be like, well, we want to gain access. Is there some way to work it out? And a lot of times those cases settle. And some people might claim a county road on the road, and we've had those issues before too. So I can go on and on.
As I say, it sounds complicated. So I want to come back and wrap this up. But
Sure.
let me ask one more question before we wrap this up. So what happens if someone starts crossing your property? What happens if it's the reverse? I'm not trying to get to my land, but all of a sudden people are driving across my land to get to their land.
Yeah. So we've had that with clients, and what we want to do is go back and look at your neighbor's title work. So their deeds, how they purchased the property, what was in the title records of their properties. Did it ever show up? When you purchase a property and when you own a property, it might show up in your own title work that there's an easement crossing your property. So usually the title company will have identified that. But if you've owned this property for years and have inherited it, most likely you're not going to have a title policy to pick up those issues. So a neighbor, all of that is in the deed records. So their deed, whatever access easement was granted to them, we can go and look and see if there's anything recorded that gave them an express right to cross your property. And usually what needs to occur is we can help you go do the title research.
Okay.
But usually you want to have a conversation with the neighbor. And there's, maybe you don't mind how they're using it now. Maybe they have used it for 50 years. There are ways to negotiate an access easement where you don't have to go to court and you say, hey, I really don't mind the way you're using it right now, but I don't want you to put in a subdivision there. So we can limit the amount of feet of the access easement because that would limit development. Or we could say, well, if it ever was subdivided more than twice, then we could terminate the access easement. There's all kinds of different ways to put parameters on the land use and have a written agreement with your neighbor.
So you can still be a good neighbor, but protect yourself.
Sure. Absolutely.
Okay.
And the best, this is a lawyer talking, but the best way to do that is through a written agreement. Because we get, what are your ideas about the things that you need and what do I need? Well, I have this access easement going through my property. I don't, I'm fine if someone comes behind you and uses it, but I want them to maintain it. What are the materials that I want you to use to maintain it? Or how will we work that out if you're doing that? Because you can think about like your relationships with people, and it's better if you flesh out those things that are really important to you and things that are really important to the other side. And if you can have a conversation about it and write it down, then it's the best way to have a good relationship with your neighbor.
So I think you just answered my last question. My last question is on this topic is, what is your advice? Sounds like your advice is talk to your neighbor, get a written agreement.
Always. I mean, I'm a litigator. I'm happy to go to court. But I have just seen it work better if you talk to your neighbor and you work out some compromise. Because in the likelihood of going to court and getting all the way to trial and winning, whatever winning looks like, is going to be super expensive.
Okay.
Right?
All
So
right.
we're talking, I've had these access easement cases cost over $100,000, $300,000, $400,000, where neighbors are just
Wow.
fighting. If it is a use that you are okay with and you can have an agreement with the other side, it's a good idea to do that. Sometimes that doesn't work, and sometimes you get sued even if you're willing to work with the neighbor. Sometimes you just can't prevent that. And we're here to help with that too. But my advice 100% of the time is see if you can work something out.
Okay. Great advice. Thanks, Cassie.
Yeah.
Okay, so let's go to HOAs. So I've been a member of many HOAs, and I've had some interesting HOA discussions with neighbors. My trash can apparently was not out of view for all 7 days of the week, and I got a notice. Or once I parked on the street overnight and got a notice. So let's talk about HOAs.
Sure. So we've done both sides of that work. I have represented homeowners who are suing their HOA, and I've represented HOAs who were suing their homeowners. And we say HOAs, and then we also use a term around here called POAs, so Property Owners Association. You and I think of HOAs like if we live in a neighborhood, and
Right.
we do that work too, but a lot of times we encounter a Property Owners Association, which means 10 acres, 15 acres, 20 acres. And there are rules within that Property Owners Association. And again, I've been on both sides of that 10 years ago now, maybe more than that. 15. Patrick and I had a case out in Edwards County, and it was so interesting. We represented the Property Owners Association at the time. And there were all these landowners that lived in Houston, but they bought land in Edwards County, and they wanted to use it as a hunting ranch. So they had exotics there and whitetail deer, and each side of the ranch had like a 700-acre pasture on this side of a road, and then a 700-acre pasture over here. And there was a POA, a Property Owners Association, and a board. One of the neighbors came in, and in the dark of night, he and another one of the landowners decided to bait the exotics, put up special feeders on their side of their property, and get all the exotics to come over. And then they fenced the pasture across,
Wow.
which was not allowed in the deed restrictions. So there was no internal fencing that was allowed. So we got all the exotics over on his property that the Property Owners Association had paid for. And we were representing the Property Owners Association, sued that property owner to say, hey, you can't build a fence. The deed restrictions clearly show you can't do that. We got into litigation. Eventually that case was settled. The fence came down. Lots of fighting about what that means. But it can happen not only in your subdivision, but also in a property owner's, a larger property owners.
So, yeah, let's make sure everybody understands a Property Owners Association.
Mm-hmm.
So what are the differences, or how do you define a POA?
Well, I mean, very similar to what you have in deed restrictions with your trash can and the car on the street. But this is a Property Owners Association might be larger acreage, usually 5 acres or more.
Okay.
And there's some common element of you're going to manage the wildlife together, or maybe there's an ag use on the property to keep your taxes low, and you're also just interested in that use. And so there's disputes that come up with that. There's people can not want you to have one. I represented a landowner, I think they're in Bell County a few years ago, and their children wanted to have, there was a dispute about ag use and what was allowed within the property owners association. And so this particular landowner that I represented had put a couple of lots together. And so he had about 50 acres and he wanted to run some cattle on his property. And really it was for a 4-H program for his kids.
Okay.
It was just, they wanted to have some animals out there. He had a much larger tract than most of the landowners that were in his neighborhood. And the property owners association sued him for putting ag animals on the tract. And the deed restrictions were not well defined about whether or not that was allowed. Of course, we thought it was allowed. They didn't think it was allowed. But it usually is amongst neighbors, there is a dispute about a use of a property. Short-term rentals are coming up a lot.
We're hearing that a lot.
Right? So that can be in a homeowners association. It can be in a property owners association. We've been on both sides of that issue too, of a homeowners association not wanting the short-term rentals, or the client saying, you know, I want the short-term rental, and they amended the homeowners association after I bought in here, or they're not enforcing the rules across the board. So one of the things that the law requires is that if you're going to have rules, then you have to enforce them the same across the board, that you don't enforce them on one person and not on the other, right? That seems fair.
Seems fair.
Yeah. And so one of the complaints I've heard from some clients is, well, why are they saying something about my short-term rental when the people down the street
are doing the same
issue? So sometimes you can make an argument in court, well, that the homeowners association or the property owners association has waived that issue because they haven't enforced it.
So in terms of, I guess, legality, does the homeowner, the association and the rules, when you buy that piece of property, their homeowner rules supersede your individual rights? I mean, that if you fight the homeowner and you are in the wrong, you will lose?
Yes. I mean,
or the POA?
When you're buying your home or your property and there are deed restrictions on the property, you should read those deed restrictions before you purchase the property and understand them. And is there anything in there that you're like, oh, I do really want to park my boat on the street. I'm not going to be able to accept that. Or, you know, maybe larger than that, like I want to have animals on my property, and that's not a use that's allowed. So you really need to read those. It also is kind of hard because sometimes realtors might tell a landowner or a property owner, yeah, there's an HOA, but they're not really enforcing anything. And they could not, that could be the case when you're buying in, that they're really not formed to enforce anything, but that could change because even if they're not enforcing them, those deed restrictions apply to you, and the HOA or the POA can file a lawsuit against you. If you're not paying your dues, they can collect those. And then the homeowners and the property owners have rights too. You're entitled to see the records and know about the board elections and make sure that you have notice of the meetings that are happening. Those are all in statute so that you can have some accountability there too.
Okay, good. So if we're going to wrap up HOA, POA, what would your advice to landowners, homeowners be around this particular?
So I would say make sure when you're purchasing a property that you understand what the restrictions are, because they do apply to you.
Okay.
When you and you don't want to get into a fight about a use of property that you really want. You should go find somewhere else to purchase, you know, if it's really a restriction. And I would say that usually it's not, you made a comment like these are deed restrictions and they're black and white. Unfortunately, the interpretation sometimes is a little, it can be up to interpretation about what is ag use. What do they mean by that? So sometimes these deed restrictions may not be well drafted, and maybe the intention there is a little confusing. So, I would invite you to make sure you don't purchase a property in a place that doesn't meet what you're trying to do with your property, and also have a conversation with the board of directors and try to work out any dispute, because they can grant variances or waivers if there's certain things, or you can organize a vote or ask that, a certain amendment be put on to change the rules. So there's some things that can be
So
done.
be educated, be aware, and know what you're getting into.
Yeah.
Okay, awesome.
Yeah.
All right, well, our third one deals with partition of land, which is a fancy way of saying subdividing, selling, breaking up.
Yeah, mostly in the when I think about a partition, I think of in the context of a lot of family land, or at least interest holders in a land. So this is crazy. Most people don't know this, but in Texas, if you are any percentage interest holder, 1%, 0.5%, you can go to a court and file a lawsuit and say, I want to partition this land to get out my percentage.
Okay.
And so you don't have to have the majority of the land. You can force a subdivision of a property if you are an interest holder.
So let's talk about that. So this would be an undivided interest. True?
True.
You want to talk a little bit maybe about divided interest, undivided interest? So
Well,
does that matter with a partition?
Yeah, it would be mostly for undivided interest. And what that means is if you're an undivided interest holder, there is not, let's say you own 100 acres and you have 25% undivided interest. There's not 25 acres that you can just point to and say, that is mine. You own a 25% interest in 100 acres, right? So
Subtle but very distinct or very important difference.
sure. So it's different to say, well, my sister and I agreed and she got this 50 acres and I got this 50 acres of my family's land, or there's 4 of us and we each got 25 acres. That would be a subdivision or a partition that you're agreeing to. But this is the case where a family owns a property. This can happen amongst siblings. It mostly happens amongst cousins or grandchildren, or just different interests, and they don't agree about how the property is to be utilized, how it's being used, or if they want to keep it together, or somebody might want to sell it. So all kinds of different, you name it, about a family thinking about a property, and that's the reason for a partition. So what happens is that family member owner can go to the court and say, Judge, I want to partition this 100 acres and I have a 25% interest in that. And the court says, okay, does anybody object to that? There's 2 different types of partition. Partition in kind, meaning I'm going to partition it out and give you each an acreage that's equivalent to your interest, or a partition in sale. A partition in sale is, Judge, because of many factors, this property is not conducive to subdividing. Maybe it's access issues, or it needs to be sold altogether. And the court can decide to do a partition and sale and require the parties to put it up for sale. So those are less interesting. The partition in kind are kind of not that they're interesting too, but the partition in kind, we do more of those. And the reason is the court has all the control, honestly.
Okay.
So it's really different than you and I coming to the table and you saying, hey, I want to get my 25 acres out between the family. And then we sit down and look at where your 25 acres go. When that lawsuit is filed with the court, you lose all ability to control what that judge is going to decide.
So let's keep with your example. 100 acres, I have 25% interest. Someone else wants to sell. I want to keep my 25 acres. And I can say, I want these 25 acres.
You can go to the court and So all the court does under the statute is appoint 3 commissioners. They're usually people that know something about land. They can ask for an appraisal of the land and a survey. Those 3 commissioners decide how it's subdivided. Now, I've been in cases where the commissioners have considered the parties' proposals of how they think it is to be subdivided, but they're not required to look at that or respect it or anything. They can decide exactly opposite. So you're really taking it out of the parties' hands. And honestly, every litigation case is like that, where the judge is making the decision for everybody because we can't agree. But I do really feel like partitions in kind have this element of, we've tried everything we can and we can't agree how this is to be subdivided. We just need somebody else to decide it and tell us what to do. Now, in that realm of litigation, you can still talk and settle things out and work out partitions, and I've had that happen.
So at any point in the process, you can regain control and say, we have agreed to something and we'll settle it ourselves? Or is it once it's over to the judge, he's going to end up saying, here's your 25 acres, no matter what?
I think you can all the way up into final judgment on the partition, so you could negotiate a settlement. Now, will the parties be willing, or you got to have parties willing? But yeah, those are really interesting. I only practice in Texas, but it's really interesting to me that I can be a minority percentage holder and still go to court and say, I want my
2%.
2%. And the reason for that is, I think, is the public policy behind, the Texan way of being able to control your land and do what you want to with it, right? And being able to own that. And when you're an undivided interest holder, the control that you have is a little less. And so there's a mechanism to gain control. Not always in the, if you're really a 2% interest holder in 100 acres, maybe it's better to keep all the land together and do something with it, because the 2% that you're going to get is not fair.
Yeah.
So I did have one case in which, in a partition, going back to what the court can do, the commissioners messed up the math when we got the recommendation to the court of how the property should be subdivided. They had given one party $100,000 more in value. It's because they equated all the acres at equal value, and there were several tracts, instead of looking at the market value of each of the acreage and dividing it out. So it ended up one party, I don't think they meant to, but one party ended up getting more valuable land. And so,
is there an appeal process?
So we had to go to the court and say, hey, court, the only reason the court can deny the recommendation of the commissioners is if it's unfair, unjust, not fair and equitable, I think are the words. And so we have to point out, hey, this party is benefiting $100,000. We don't think that's fair and equitable. And the judge agreed. And then the only remedy is to appoint 3 more commissioners and go through the process all over again. Because that's what the statute says is the process. So it's very different than some of the other litigation processes that you might go through, because it's unusual to have 3 strangers who are deciding how this is to be subdivided.
And they can listen to your proposal or not listen and do whatever they want, as long as it's fair and equitable.
Yeah. And the way we've done it in certain cases is each party or a group of parties might appoint, say, I want this commissioner. Okay, you appoint one. So everybody kind of has representation, but you don't meet with them. You're not talking to them. It's all in writing and what they decide. So,
wow.
Yeah.
Interesting. All right. Well, thank you.
Yeah.
All right. So we have covered easements, HOAs, POAs. That was partition of land. Let's talk about nuisance. That's a very big word. So give us a little context for nuisance.
This is the concept of my neighbor is flooding my property. My neighbor has loud music going all hours of the night. I've got a quarry next to me and it's very loud. My neighbor's cattle are getting out and they're destroying some of my property. So anything that is a property damage or just interfering with your enjoyment of your land is a nuisance. Now, I often ask clients, like, is this something we can work out with the neighbor? Because nuisances are, while they can be very annoying, it's like, what's the value? Is it worth filing a lawsuit? They're usually, some are bigger, like my property's being flooded and I can't use it. That's a big one.
Right.
But usually the phone calls we get are smaller nuisances. And so we're looking for a way to work that out, maybe send a demand letter, kind of come to some agreement about how is your neighbor's use of the land affected? Years ago, I think this story is so funny that years ago I had a potential client call me and they were very annoyed with what the neighbor was doing on their property. And there was a dispute about their fence, and the neighbor was writing ugly messages, and they were blaring, loud music. And I listened and listened and listened, and I was like, okay, well, I love asking clients, in the end, if you could have everything that you wanted, what would be your goal? Let me understand, what is it that you're working for? And this potential client said, I want her to move. And I said, well, there's not anything I can do in the legal world that is going to convince your neighbor to move from her house. Even filing a lawsuit against her for all these very annoying things that she's doing, or calling the sheriff or calling the cops. We can't force her to move, right? If that's the goal. You probably should just, learn to live together. So I don't mean to be flippant about nuisances, but you're often asking the question of, is this something that is so big that is how do I determine the damages? Like, I had these trees destroyed or my property is being flooded, because there's got to be some damages associated with something that you can recover if you did file a lawsuit.
Okay, I was going to say, so is it litigation then? Is that what this would be? Yeah. I am going to sue for these just damages. I get a flood. For what, like loud music? They play loud, annoying music. What?
Yeah. I mean, in that case, I'm going to tell you, call the sheriff, because there's usually an ordinance, a city or a county ordinance about how loud it should be.
Or barking dogs.
Dog, whatever that thing is. So the first question is, what is your damages? Is it something that we can recover for? And I always tell people, you're not going to get attorney's fees. So a lot of people come in and they say, well, I want to see my neighbor and I want them to pay for my attorney's fees. But in nuisance claims, attorney's fees are actually not recoverable. So that sometimes
it's going to cost me something to get them to stop doing that if I end up going the litigation route.
That's true. And I always tell people too, I'm never going to launch into a lawsuit without sending a letter to the neighbor first and saying, hey, we have this problem. This is how I'm proposing that we fix it. I want you to do these things, and give them a chance to respond and a deadline by which to respond. But I always recommend trying to work it out first, and then advising the client, especially on something like this, what do you think the damages are? Because if they're like, I probably have $5,000 in damages, then we're not going to be able to file a lawsuit for that amount of money to recover it and make you whole. So and I know one of the things that you do really well, Cassie, is you talk about a budget. You talk about what this is going to cost. Yeah.
So to walk us through a little bit about that, especially like in a nuisance case.
Yeah. So every potential client, I think we do a good job of that at the law firm, of talking about the business side of it. So I get it. It really is, it's bad when you're, when you don't have access to your property, or in a nuisance case, you're really annoyed by something. But I often ask the client, what's the goal? What do you want to get out of it in the end? And also, how much are you willing to pay to fix the problem?
Okay.
Knowing that you're probably not going to get any of this back, what does it mean to you? And, we don't have this on the list today to talk about, but property tax cases, even if we're going to settle those out, those are somewhere between at least $10,000 to $15,000 that, just to get the attention of the appraisal district and get it settled and do, even if we don't go all the way to trial. But litigation is expensive. And so, I've had cases that cost, a lot of money, over $1 million. I've had cases that are kind of $500,000, $400,000. And how much those are costing and the resources that your family is using to fight that is real.
Yeah.
So I don't want to get into a litigation with you where we can't move forward on a certain strategy because we don't have enough money. Or if we only have so much money to use, how do we use that strategically?
Yeah.
How do we go, okay, we don't have $100,000 to spend on this, but we've got 50, and what would we do for that? And we can tailor our strategy based upon that. I think budget and being clear about expectations is very important, and it's a role that we have to make sure that you understand, because most of the time clients are coming in and they're dealing with something very difficult.
They're mad.
They're mad.
Yeah, they're mad.
They're very upset.
Let's sue them.
Right. Like,
Let's
I
get this
want to
done.
get
I want this get done.
I want to knock them out. Right. And then when I say, well, okay, I hear you. I think you've been wrong too. Is it worth $100,000 to you?
Are you $100,000 mad?
Yeah. And so
Which
we
is
were
a
like,
different question.
Yes, because, in the context of access easements, I don't have access to my property, so I have to get that. My property's worth $0 if I don't. It's landlocked. So, that we have to have that conversation.
Right.
But most of the time, it is something, either we work it out or and sometimes people, unfortunately, get sued. So we do a lot more probably plaintiff's work than we do defense work, where we're being more proactive in our suits. But we've also had clients that were sued over access easements or nuisance, or sued by their HOA.
All of these things that we just talked about.
Yeah,
Right?
We're on the defense side.
Okay.
And so, they're like, I didn't do anything. I
didn't start this,
I didn't
right?
start this,
Yeah.
right? I've been sued, but they've got to defend themselves. I've had a client that was, two clients that were both sued on access easements, where the neighbor is claiming the access easement and the client has to step up and defend themselves. So real conversations about, what does that mean? What does this mean to you? Could you give them an easement and be okay with the use that they have? And letting them, it's important that lender is making the decision about their finances and what they want to do and what's important to them.
No, I think that's so critical to get a whole picture view of this, and not just start down a path you can't finish. So.
Yeah. And luckily, I've been practicing for 20 years, so I've seen the gamut of, what it takes to get something done. So I'm not afraid to tell someone the real number.
Yeah.
And I also don't want to be in a relationship where they're like, well, you didn't tell me. Some things are unpredictable. So let me say
Of course.
that. Sometimes I don't know where a case is going to go, but if I do have any idea of what we've done in the past and what it's cost, I'll use that as a historical number. Like, well, the last access easement case we had to defend was X. It depends on the dynamic of the other side, but yeah, happy to discuss budget.
Yeah,
I think
great
that's really
conversation.
important.
Thank you. Okay, so our last one, damage to your property from adjacent development. There is development going on everywhere.
Yeah.
I don't know that there's hardly a thing as real rural land anymore. It feels like all kinds of land is being subdivided, split, broken up. We've got wind projects, solar projects, oil, gas, road, construction everywhere. Mm-hmm. So what are you seeing that has prompted this to be number 5 on our list for landowners?
It probably should be. It's also like one of the big issues. So what we're seeing with owners of rural land is a development goes in next to you. They haven't, there's all of a sudden your property is being flooded. There's usually, there might be an easement there. There might be a drainage that they're using to go through your property. There are laws about what someone can do under the water code about diverting water. And so usually a development, this is my landowner perspective, not a developer perspective, but they're using stormwater controls, retention ponds, those kind of things to contain and slow water going across their property. Because think about it, if you think about before you put houses on a property or really any infrastructure, the water is flowing a certain way. And then when you add houses and driveways or a solar farm, it's changing the course of that water. So the developer, your neighbor who's the developer, should be doing engineering studies to make sure that that water, if they're changing the flow of it, that they're not impacting the neighbor. And they have to look at, are they increasing the flow? Are they diverting it onto the neighbor's property? And many, many times they don't get it right. And I always think of engineering as an art, not a science. So just like lawyers can disagree about the solution, engineers will disagree about the solution. Well, I would have designed it this way. I would have done it this way. Oh, they didn't put the proper controls in. And so we're seeing that on both residential development, but what's really new is on solar farms. So we've had a case or two where solar farms are being built and the client's property is being flooded, and we're in active litigation over those where the flooding is occurring on our client's property, and we've sued the developer of the solar farm. But on the reverse side of that, we also negotiate wind and solar farm leases for clients. So we are seeing we're in a unique position, I think, to see what happens when you put them in and you're not taking care of it. And also to be on the landowner side where I'm leasing out my property. How do I make sure that I'm not on the hook if they get their engineering wrong? Right. So we've started changing some of the terms to say, hey, I don't want to be liable for stormwater that's on my property. And so, I think the law firm is uniquely suited. We meet a landowner where they are, and our interest is advocating for landowners. So we've been on both sides of the issue, and we're trying to figure out what is the right legal issue there. You will see our name both advocating for landowners to be able to use their property in the way they want to use it, to monetize the income from the property, and also making sure that if a development is going in, a landowner has every right to develop their property. Right. For a solar farm or for residential, it's inherent in their rights to sell that. But then how do we make sure that the neighbor's not being impacted by that if the engineering goes wrong, or if there's not plans for how to deal with this with the stormwater that's coming off? So
much of this seems to come back to being a good neighbor.
I know. I think so too.
Just be a good neighbor.
Do unto others. It's, I do counsel my clients on that of, and I use that framework. Sometimes it doesn't always work.
Sure.
And sometimes you have to, you're using that leverage of what string do you pull to get someone's attention. But I do believe a conversation amongst neighbors is really important first, if you can work it out. And giving somebody an opportunity to fix the issue is always where you should start, because oftentimes it's a conversation where you've never even had the conversation. So I always start off, well, have you talked to them? And sometimes it's, well, they won't talk to me anymore, or yes, but it's been heated. And sometimes I can reach out. And it can feel threatening if it's a lawyer, but I've done enough of it that I think I'm pretty good at it. And when I call the neighbor that we're in a dispute with, I will often say, hey, I'm a lawyer. Your neighbors asked me to call you, but I'm not wanting to threaten you with anything. I'm just here to talk to you. And that's worked a lot of times and then I'll listen, because what I'm listening in for is, where do I see that commonality? Where is it that we can agree? What is it there? And I do think that tactic has helped me on that road that I was talking about, where we're negotiating over the multi-landowners. I start the conversation by saying, my client doesn't want to develop his property. He just wants to document the access easement that his family's had for 100 years. And I want to help him do that. Now, we can always go to the courthouse and we would have an argument for a prescriptive easement, but I don't really want to do that. Neither do you. We're spending all this money. So let's see if we can work something out. And so far, I don't have them all negotiated, but it's working out so far. So
That's great.
I love
that approach.
Yeah.
I love that approach.
It's good.
Well, Cassie, thank you. I think that was a great view of actually you and the firm's philosophy on how you handle a lot of things, the way you approach things. Gave us a good look at litigation issues that landowners are encountering every single day. So thank you for bringing that forward. I hope it was great information. That's actually a wrap for today's episode of Your Texas Land. Hope you enjoyed our conversation with Cassie. Cassie, thanks again.
Yeah.